Good morning. Want to touch on working while you have a pending claim. As you probably know by now, you can do that if you do it smartly. There are certainly black and white rules that you have to follow, and we have those in other videos. That would include SGA, staying underneath SGA. And then, of course, for later considerations, you might want to consider whether you want to stay under the TWP amount, also while your case is pending. But there is a danger, like if you are earning less than SGA, but your hours are getting really steep, 25, 30 hours a week, and you're under SGA, the optics might not be very good to an adjudicator or a judge. And even though it's under SGA, the ability to put that many hours in might really, really kind of fly in the face to some adjudicators that you could maybe pull off another 10 hours or 5 hours even and make it mid-30s, which is kind of considered full-time. So I always say, you're supposed to be concentrating on your well-being. If you can keep it 15 hours or under a week, that is really what I, try to encourage people to try to do. I know sometimes, financially, that's just not possible, particularly if you're a low-income worker. So you're trying to pull out more hours than that, but it is at a risk. One way to maybe mitigate it, and again, it's not going to necessarily totally mitigate it, but if you have a job that the reason why you can do 30 hours is because there's so much downtime, your job is like you can even go lie down for a few hours in a shift if it's some sort of unique, interesting job like that. Get confirmation of that. Maybe get a job description with where the allowances are. Or if you're doing a job and it's accommodated where the normal title of the job wouldn't presume this, but your particular boss lets you, let's say it's, you can lie down in between customers or, I don't even know which job we might be talking about. But if there is ability to do things that basically it's non-work time, even though you're getting paid for it, like lying down, you need to get documentation of that from a credible source that is objective, such as the employer, that they're accommodating you because this job, it's fine. You don't have to be sitting in an upright chair waiting for the next customer. You could be lying down in the back or whatever. Whatever you can do to show that this might be 30 hours. And again, I don't think you should even do 30 hours. But if you are and you're under SGA, getting objective evidence that this is an accommodation. You're getting special favors basically by a kindly employer who either is doing that out of kindness or because you're the only person that wanted the job. Who knows? But that can really go far to maybe not let someone have the impression that she can do 30. She could certainly do 35, right? I mean, I would even think that. So, but if it's something where it's an accommodated job, that kind of takes it out of the realm of a job that exists in substantial numbers in the economy. And therefore, that's not one that they can necessarily consider if it's the accommodation. And it's not the accommodation, the accommodation I'm talking about is one where you are actually not working that many hours. You're just getting paid for them. Like if you are, sometimes it's been someone who's worked for maybe a family friends company, small business, and the person just wants them there for the 3 phone calls that come in. Maybe it's like a service business, heating, ventilation, plumbing, and they just need someone who answers the phone and there's not that many phone calls. Or maybe it's some sort of job where they need it to be done and maybe you got an in through family, but you're really not working the amount of hours or you're not really earning the amount of pay you get. It's just kind of like an accommodation and a kindly thing. That can really go wonders if that employer will document that for you and say, yeah, we give her all sorts of accommodations because it's the only way she can do it, or he. Um, and our limited need is this, but no one's going to come in, and get paid, for the 3 phone calls if it's not going to be a 5-hour shift. So we have to make a 5-hour shift. However it's going to be defined by that employer. And again, sometimes, depending on if the employer, they probably would write that. If it's true, they probably would be. Sometimes you get an employer who, if you're not close with, they're a little paranoid, and they seem to think, oh no, I can't get involved with the federal. It's not the case. It's literally a letter signed by them, perhaps on letterhead, and it just goes to the adjudicator or the judge into the file. There is nothing else. It doesn't go for taxes or anything else. But it can, that's a more objective source that can really credibly explain what, if you are saying the same thing, and you probably have, it's not going to hold as much water because you are the claimant themselves. So that would be a more objective piece of evidence supporting the fact that that is not work that exists in substantial numbers in the economy, even though the title might. Like if you are sales clerk, well, you're just sitting in the office waiting for phone calls. There'll be 3 during a day on a typical day, and you're supposed to explain to them what you guys do and see if they want to hire you. I mean, you know what I mean? Like it could be really the most minimal effort, only 3 times for 15 minutes each, in a whole shift, and that could explain why you were able to do it, because it's not like you're in a big call center, selling things and being on your feet and fast talking, trying to make a sale. So you really want to point that out, and those accommodations are worth their weight in gold if you can get them confirmed by the employer. I had a case once where it wasn't the employer confirming them, and it wasn't official accommodation. It was, I would say, unofficial, and coworkers were doing some of the more arduous tasks that their beloved coworker, who was really becoming quite deteriorated, would do. And it was kind of heartwarming to see these people step up and do a letter explaining, yeah, this is what I do when I see him slowing down. And I see him have to put his foot up and it's swollen and he just takes off it, in the break room. So then I go, when I see that we need something over there, I go and get it. I don't make him go get it. So that all these little things that even a coworker in an unofficial accommodation of sorts and helping the person can really create the evidence necessary to show that multiple hours a week you're doing in a week isn't really activity all those hours, that there's a lot of downtime and accommodation. So for those of you who are working on the heavier side, but it's because someone is accommodating you, you really want to get that documented if you can. Not always possible, but whenever you can, I would try to get it, because the hours are going to look bad. And even though you testify to the fact that, yeah, but I'm allowed to go lie down, you could, and a judge could believe you or might not, but it's going to be harder to disbelieve you if you have a objective third party, a coworker, a boss. A supervisor is ideal, ideally on letterhead. But again, sometimes they're very concerned about doing that. Maybe because their boss doesn't know this is going on, that they are being super kind to you. There could be a plethora of reasons, but if you can get that, sometimes it's just a coworker. Sometimes it's a coworker that doesn't even work there anymore. You got to really think outside the box and get that proof. Because otherwise there's a decent chance that the optics of being able to put that many hours in, even though it is officially under SGA, might speak something about your capacities that are more than what they really are. So you want to make it really clear and proven that that is not the case. All right. Talk to you later, guys. Bye.